Court of Appeals upholds major gun law, and the reasoning should terrify every American. Right now, only 2 states force you to pass a background check just to buy ammunition. California started it, and like a disease, it spread to New York. How many more will follow if we let this stand? Don't be fooled. This has nothing to do with safety. This is pure control over your right to keep and bear arms. But apply it to the Second Amendment, and courts actively defend it because of their own agenda. Unfortunately, it happened again. The court upheld ammunition background checks, and their justification is absolutely insane. If you believe this violates our rights, smash that like button and subscribe right now. It's free and helps us spread this message. The battleground states. California and New York are the only 2 states currently enforcing ammunition background checks, and both are facing serious legal challenges right now. The California case is called Road vs. Bonta, being heard in the Ninth Circuit Court of Appeals. The New York case is New York State Rifle and Pistol Association versus James, currently sitting in the Second Circuit. Here's what makes this particularly concerning. Both circuits have historically shown extreme hostility towards Second Amendment cases. The Ninth Circuit covers 9 western states, including California, while the Second Circuit covers New York, Connecticut, and Vermont. That means roughly 60 million Americans live under the jurisdiction of these 2 courts. Between 2008 and 2022, the Ninth Circuit ruled against Second Amendment plaintiffs in over 90% of cases that reached them. The Second Circuit's record is almost identical. These aren't courts known for protecting gun rights. They're known for finding creative ways to uphold restrictions. What's even more alarming is that the judges on these panels were appointed specifically because of their views on gun control. This isn't about impartial justice anymore. But here's something most people don't realize about how these cases actually work, and why the recent Second Circuit decision is so much worse than it appears on the surface. Bruin Framework. Ignored. In 2022, the Supreme Court handed down a massive decision in New York State Rifle and Pistol Association versus Bruin. This case was supposed to change everything about how courts analyze gun laws. The court established a clear 2-step test. Step 1. Does the law regulate conduct covered by the Second Amendment's plain text? If yes, move to Step 2. Step 2. Is the regulation consistent with the nation's historical tradition of firearm regulation? The government must prove historical analogs from the founding era or Reconstruction era. This was supposed to end decades of courts using interest-balancing tests where they just weighed public safety against individual rights. Justice Clarence Thomas wrote the majority opinion specifically to stop that practice. Since Bruin, lower courts were supposed to apply this framework consistently. Some have, many haven't. The Second Circuit just proved they have no intention of following it. In their recent decision upholding New York's ammunition background checks, they claimed the law doesn't even trigger Step 1, meaning it doesn't implicate the Second Amendment's text at all. Think about that. Ammunition is literally useless without firearms, and firearms are useless without ammunition. They're inseparable, yet this court claims regulating ammunition purchases doesn't touch the Second Amendment. But the way they justified this conclusion reveals something even more dangerous about judicial activism. Meaningful constraint loophole. The Second Circuit introduced a phrase that should alarm everyone: meaningful constraint. They ruled that New York's ammunition background check law doesn't meaningfully constrain the right to keep and bear arms. Therefore, it doesn't even implicate the Second Amendment. This is not in the Bruin decision. This is not in any Supreme Court precedent. They made it up. Here's why this is catastrophic. Who decides what's meaningful? There's no objective standard. It's completely subjective, based on each judge's personal opinion. One judge might think a 3-day waiting period isn't meaningful. Another might think a 30-day waiting period isn't meaningful. A third might think an outright ban on certain ammunition isn't meaningful as long as some ammunition remains available. The word meaningful has no limiting principle. It's a blank check for courts to uphold any regulation they personally support. This directly contradicts Bruin's framework, which requires courts to look at text and history. not to weigh whether an infringement is big enough to care about. The Supreme Court explicitly rejected this kind of analysis. Imagine applying this standard to other rights. A law requiring a background check and fee for attending church doesn't meaningfully constrain religious freedom because you can still practice your religion at home. A law requiring government approval before publishing online doesn't meaningfully constrain free speech because you can still speak in person. Absurd, right? But there's actual data showing why this matters more than theoretical concerns. False denials data. California's ammunition background check system has been operational since 2019, giving us hard data on how these systems actually function. In the first year alone, the system generated over 16% initial denial rate. That's not 16% of criminals being stopped. That's 16% of all attempted purchases being flagged. The vast majority were false positives. Law-abiding citizens with clean records were denied ammunition because of database errors, name confusion, or system glitches. California's own data showed that 11% of all denials were overturned on appeal, meaning the system wrongly blocked thousands of legal purchases. But here's the problem: most people don't appeal. The appeal process requires submitting additional documentation, paying more fees, and waiting weeks or months for resolution. Many people simply give up. They've already been denied once. They don't want to deal with more bureaucracy, so they just don't buy ammunition. Beyond false positives, the system costs gun owners money and time for every single purchase. California charges $1 per background check. That might not sound like much, but it adds up. Someone who shoots regularly and buys ammunition monthly pays $12 per year just for the privilege of exercising a constitutional right. New York's system charges even more. These fees are regressive taxes that disproportionately affect lower-income gun owners. But the cost and inconvenience aren't even the worst part of what these systems enable. Registration backdoor exposed. Ammunition background checks create a de facto ammunition registry, and by extension, a firearms registry. Every time someone passes a background check to buy ammunition, the state records what caliber and quantity they purchased. Over time, this creates a detailed database of who owns what types of firearms. If you're regularly buying 9mm ammunition, the state knows you own a 9mm firearm. If you're buying .223 Remington, they know you own an AR-15 or similar rifle. If you're buying 12-gauge shotgun shells, that's documented too. California maintains this data indefinitely. There's no sunset provision, no automatic deletion. The state has a permanent record of your ammunition purchases going back years. This is exactly what federal law prohibits at the national level. The Firearm Owners Protection Act of 1986 specifically banned the federal government from creating any system of registration of firearms or ammunition. Congress understood that registration leads to confiscation. History proves this pattern repeatedly. Australia used registration data for their mandatory buyback in 1996. The UK used registration data for their handgun confiscation in 1997. Canada used registration data for their recent AR-15 confiscation. When governments know who owns what, they can efficiently target those owners when political winds shift. New York's system works the same way. Every ammunition purchase creates a permanent government record of your firearms ownership. But beyond registration concerns, these systems reveal something darker about government control over rights. Other rights threatened. If courts allow background checks and fees for ammunition, what stops them from allowing similar restrictions on other constitutional rights? The logic is identical across all rights. The government could require background checks before attending protests, arguing it's just a modest condition that doesn't meaningfully constrain your First Amendment rights. After all, you can still speak at home. The government could require fees and background checks before accessing news websites, claiming it's necessary to combat misinformation. You can still get news from other sources, so it's not a meaningful constraint. The government could require background checks before hiring an attorney, arguing it prevents criminals from gaming the legal system. You can still represent yourself, so your Sixth Amendment rights aren't meaningfully constrained. The government could require background checks before voting, claiming it ensures election integrity. As long as most people can still vote, it's not a meaningful constraint on suffrage. These aren't hypothetical slippery slopes. They're the logical extension of the Second Circuit's reasoning. Once you accept that constitutional rights can be conditioned on government approval, background checks, and fees, there's no limiting principle. The Constitution becomes suggestions instead of guarantees. Rights become privileges granted by government rather than inherent protections against government. But the most frustrating part is how inconsistent courts are when applying these standards. Circuit split created. The Ninth Circuit and Second Circuit reached opposite conclusions on virtually identical ammunition background check laws. In July, a three-judge panel of the Ninth Circuit struck down California's law, holding it facially violates the Second Amendment. The court applied the proper Bruin two-step framework, found the law implicated Second Amendment rights, then determined California couldn't meet its burden of showing historical analogs. The decision was clear, well-reasoned, and followed Supreme Court precedent. Less than 3 months later, the Second Circuit upheld New York's nearly identical law, using completely different reasoning. They skipped the Bruin framework entirely, claiming the law doesn't even implicate Second Amendment rights. Same type of law, same constitutional provision, opposite results. This is called a circuit split, and it's exactly the situation that typically prompts Supreme Court review. When federal appeals courts disagree on major constitutional questions, the Supreme Court often steps in to resolve the conflict and provide clarity. That's likely what will happen here eventually, but circuit splits can persist for years before the Supreme Court grants review. During that time, your constitutional rights depend entirely on where you live. Gun owners in California might see their ammunition background check law struck down permanently, while gun owners in New York remain subject to the same restriction. Yet there's one more aspect of this case that reveals the true extent of judicial manipulation. Judicial activism exposed. The Second Circuit's decision demonstrates a common tactic among activist judges. When you don't like the Supreme Court's framework, simply claim it doesn't apply. Bruin established a clear two-step test for evaluating gun laws. The Second Circuit acknowledged Bruin exists, but then concluded they don't need to apply it, because the law doesn't implicate Second Amendment rights in the first place. This is circular reasoning. They're using their conclusion, that the law is constitutional, to justify skipping the analysis that would determine whether the law is constitutional. It's the equivalent of saying, we don't need to check if this violates your rights, because we've already decided it doesn't violate your rights. The opinion cited no Supreme Court precedent supporting this approach. They didn't cite Heller, McDonald, or Bruin for the proposition that ammunition regulations fall outside Second Amendment protection. They couldn't because none of those cases say that. Instead, they relied on pre-Bruin circuit precedent, the exact type of interest balancing analysis that Bruin explicitly rejected. The Supreme Court told lower courts to stop doing something, and the Second Circuit did it anyway while pretending they weren't. This isn't judicial interpretation. This is judicial resistance to binding precedent. When lower courts refuse to follow Supreme Court decisions they disagree with, it undermines the entire federal court system. It creates legal chaos where rights depend on which judges hear your case rather than what the Constitution actually says. And until the Supreme Court directly reverses these decisions, activist judges will keep finding new ways to ignore constitutional protections they personally oppose. The Second Circuit just proved they'll ignore the Constitution to push their agenda, and we need to keep exposing this. If you found this information valuable, hit that subscribe button right now and smash the like. It helps more people see what's really happening to our rights. Share this with every gun owner, because most people have no idea how bad it's getting. Thank you for watching, and stay vigilant out there.